This is the American Law Journal.
Almost 10 years ago, new laws passed to cut down on bankruptcy. Well, that didn't work. Consumers got hurt. The banks didn't win either. And now lending institutions are actually considering modifying loans in ways they thought they never would have. Good evening. I'm Christopher Naughton. This is the American Law Journal. And back in 2005, banks got their wish. They got Congress to pass controversial bankruptcy laws. And then those laws ran headlong into the Great Recession of 2008. Where's it ended up? Gina Passarella, with the Legal Intelligencer, has this.
Today we take an important action to continue strengthening our nation's economy. The bipartisan bill I'm about to sign makes common sense reforms to our bankruptcy laws.
2005, the most sweeping bankruptcy changes in a generation, both criticized and hailed as the banking lobby's greatest all-time victory. The controversy? According to banks and lending institutions, consumer bankruptcy fraud had been growing out of control. They pushed for a strict law that would force more debtors to file under Chapter 13 instead of Chapter 7, meaning they couldn't walk away from their debt, but to a large extent had to pay their creditors back. But then, the economy tanked.
No one's whispering about the R word anymore. Now they just come right out and say it.
The probabilities of a recession have moved
slipping toward a recession.
The new bankruptcy laws ran headlong into the Great Recession. The housing market collapsed. Many homes were underwater, worth less than existing mortgages. And consumers found out that, despite the new laws, they were still able to file a Chapter 7 bankruptcy anyway.
We also saw that there was a higher rate of secured debt. So to the extent secured creditors take larger pieces of the pie, unsecured creditors have smaller pieces.
Secured creditors, such as automobile loan lenders, found the new laws helped them. But unsecured creditors, such as credit card companies who pushed for the new law, lost out. But they weren't the only losers. The contention is consumers, lawyers, and judges are left with a system far more complex and costly than before.
For Chapter 13 cases, wage earner bankruptcy, at the national level, there was a 27% cost of access increase. With respect to Chapter 7 cases, nationally, there was a 48% increase in attorneys' fees. And what we found was that attorneys are charging more because it is a much more complex, time-consuming system, but they're not earning more,
suggesting that the bankruptcy laws of 2005 may need to be revisited.
The bankruptcy system provides an important remedy. It is a safety net, and the fact that some people are being priced out of the system should be a troubling finding.
For the American Law Journal, I'm Gina Passarella.
All right, three guests with me tonight on the program, and your telephone calls as well. Let's go ahead and meet my guest. George Lutz joins us for the very first time this evening, and George has been practicing since the 1980s. It's taken us a while to get you here, George, but you are here.
Happy to be here.
Debtor's attorney with Case D. Giambrardino and Lutz, and George anchors their Allentown office. The Honorable Richard Failing is with us, also a first-timer on the program, a U.S. Bankruptcy Court judge. He is in the Eastern District of Pennsylvania, in Reading, Pennsylvania, a former creditor's attorney with Stevens & Lee. And our creditor's attorney tonight, our current creditor's attorney, is Brian Smith with Lamb Rubenstone. He represents the banks and the lending institutions. Folks, 1-800-426-4625. I'll give it to you again, 1-800-426-4625. There it is. Call early, because if you don't, you won't get your question answered tonight. You can also email your questions at info@lawjournaltv.com. Okay, we've got about 7.5 years, a little bit of perspective since this bankruptcy law came down in 2005, this controversial bankruptcy bill. And what about this bill, 7.5 years on? Did either prevent abuse, as it said it was supposed to do, or protect consumers? I had a congressman on the program going back to 2005, and I said it sounded a bit Orwellian to me. Was I correct?
I think it's could be characterized as that. I don't think it prevented abuse, because I don't think there was that much abuse to begin with. The law was premised, law had a false premise, and that is that there was rampant abuse in the bankruptcy system. I don't think that was the case then. It's certainly not the case now.
I would have to disagree with you a little bit, George. From my perspective, a creditor's rights perspective, and I've been practicing for 21 years, what I would often see in my mortgage foreclosure cases is serial filers. That same borrower or mortgagor filing a bankruptcy, getting it dismissed, doing a U-turn literally on the courthouse steps, running right back in, filing another bankruptcy and another, willy-nilly, and thwarting my clients from getting to sheriff sales and getting the properties ultimately foreclosed.
Okay, so they were serial filers is what you were saying. Did
Yes.
that Bankruptcy Act of 2005 actually address that issue?
Yes, there were a number of provisions that were put into place to try to curb, or at least with the intent of curbing, serial filing. Chief among them being that if one of these people had filed a bankruptcy that was dismissed under certain conditions, and then a year went by and they tried to file another bankruptcy, they would have to pass literally a good faith test in order for that new bankruptcy.
Okay, so it did cut down on the serial filing. Judge, you were going to say?
Judge, I would say that the biggest change was taking the Chapter 7 filers who had income and had some ability to make monthly payments and forcing them to file Chapter 13. There was no fraud. There was nothing improper in what they were doing, nothing where they were gaming the system or anything. But it's just that they were allowed to file a Chapter 7 liquidation even if they could have made some monthly payments to pay their creditors.
Fair enough. And again, part of this bill was to get more people into Chapter 13 so they'd start paying something back. Under Chapter 7, a straight bankruptcy, people are not going to be paying anything. But the question
that didn't work.
Yeah, right. They don't have to pay anything at all. They're basically cashing out. Chapter 13, you're not going to pay everything probably anyway, especially to unsecured creditors like a credit card company, but you're going to have to pay something back. But did that happen, though, George? Did that really happen in the end? There was a spike in 13s, and then they went away. People were filing Chapter 7s anyway.
I don't think in the end it did happen. I think that what the new law has resulted in is that people who file Chapter 7 and any bankruptcy have to prove themselves more. Before, they could testify under oath. Generally, the Chapter 7 and 13 trustees would believe them or have not much documentation as a basis for what they were saying as to what their income was, what their assets were. Now, debtors counsel like myself and our clients have to do more. We have to provide the documents. We have to show support for what we are asserting in our bankruptcy petition. So we have all that work to do, but at the end of the day, I don't think there's much of a change. Those who could file 7 before pretty much file 7 now. There are some exceptions, but generally, I don't think it's changed much at all.
This is actually an email we've gotten from one of our viewers, from Don H. in Radnor. He said the bankruptcy law of 2005 is probably one of the most badly written pieces of congressional legislation. It has created infinite unnecessary headaches for millions of bankruptcy filers during its 7.5 years. But partly because of its dreadfully bad drafting, most of the law's changes have not changed the end result for most people needing bankruptcy relief.
I agree with that completely.
Okay. So the end of the year, so really, in some ways, Brian, we're almost back around to the top of the circle once again, or at least debtors' attorneys might feel that way. Perhaps you feel that some of your clients did well, but let's face it, your credit card company clients didn't really do very well with these new laws. And especially once the Great Recession hit, credit card companies who had hoped to get something out of this bankruptcy bill really didn't do so hot.
No, I would have to agree with you.
And yet they were the ones really behind the bill. If I read the statistics correctly, I think $40 million was spent during the election right around 2004 on this issue by the banking lobby. And over a period of 8 years, $100 million, they didn't really come away with very much.
No,
right.
I don't think they did in the long run.
Right.
And that's because of the false premise. The premise was there was a lot of fraud. Now we have a lot of documentation that's required. That fraud didn't exist then, doesn't exist now, but it costs so much more to show Brian's clients that there is no fraud.
Right.
And so my clients, they jump through a lot more hoops, but they do jump through the hoops. And at the end of the day, they're where they would have been otherwise.
Yeah, Judge, it's interesting because, again, this bill, which still is having an impact today, even though it was over 7 years ago, was based on this premise of abuse. And yet, I would say, you tell me, people filing bankruptcy in 2003 versus 2013 is probably pretty much the same.
There are many fewer filing today, at least in the Eastern District of Pennsylvania where we are. There are many fewer filing today than they did in 2003. The filings, however, have a lot more paperwork. There are a lot more requirements. Whether they're effective, whether they're doing what they were supposed to do. The real bugaboo is the confluence of BAP-CEPA, of the 2005 amendments, and the recession. If things were a booming economy from 2008 through today as they were before BAP-CEPA,
right,
then maybe we'd be someplace different. Maybe it would have worked. Maybe things would be different. But nobody anticipated the bottom falling out as it has in 2008 and continuing through to today.
Let's take a quick look at this graphic, and you'll see who inspired us to put this graphic together. These are the suggestions, George Lutz's suggestions, on why people declare bankruptcy today. Job loss, probably right at the top, is injury and medical. I think that's right at the top. But job loss and injury medical are at the top. Divorce, bad decisions, and quote unquote, I like this one, George, loving their children too much. But certainly of your top five there, job loss and injury medical, no doubt, are right at the top.
Yes, that's right, especially in this economy.
Right. And that hasn't changed much in 10 years.
No, I don't think the changes, 10 years ago, I don't think those factors 10 years ago would be much different than they are now.
With one exception, going back to something that I said before, Chris, 10 years ago, 11 years ago, you'd have not only the serial filers, but the people who were threatened to be on the receiving end of, say, a sheriff's sale, filing bankruptcies for no other purpose than for just temporary relief, staving that sheriff's sale, staving that automobile repossession with no realistic intent of an end goal in mind.
So again, the auto lenders did definitely secured creditors who were loaning monies for automobiles did fine. Because they had something, I mean, there was an asset where they had a secured interest.
Chris,
and they had better lobbyists than
let me jump in here, Chris.
Yeah, go ahead, Judge.
Yeah, what I find, however, going back to Brian, is his clients, the creditors, they aren't foreclosing. They aren't taking the homes. They're letting the debtors in limbo.
Right.
They're leaving debtors with a tough choice between doing nothing and getting burned and doing something and getting burned. And it's very frustrating for debtors' counsel. They come into court all the time saying, I wish we could do this, I wish we could do that, but it all depends on the creditors actually doing something.
And Judge Failing is correct. You're seeing more and more on the creditors' end as well. Creditors proceeding to a certain area and not going past that area. A foreclosure, for example, a foreclosure action's filed, judgment is taken, but in past years where the creditor would at that point just proceed to sheriff's sale, do not pass go, do not collect $200, that creditor is now saying, no, I don't want to go to sheriff's sale. I'm going to put things into stasis for right now, and maybe I'll talk to the borrower, maybe I'll reach out at this point, but I really don't want to go to sheriff's sale if I don't have to.
It's a big problem. Brian's clients don't want to own the real estate because they can't sell it either. Right. So my clients end up owning real estate that they have a legal interest in, but not a real interest in, and they are, as the judge said, they're really in a limbo.
So in some ways, we've come back around full circle, but if not much has changed as far as the dynamic goes, and certainly the number of filings is about the same as it was before 2003, what we certainly can agree on is that we have a far more complex system and a far more costly system. It costs a whole lot more. If I were to file a Chapter 7 today, and I don't mean just because of inflation, even if you use $2,003, it's going to cost me a lot more to file a bankruptcy today, comparatively, than it did 10 years ago. And that's as a direct result of this act.
Yes, that's correct. And as I said, again, the false premise that fraud was occurring, now we need to show that fraud is not occurring. That's a lot of documentation. That's a lot more work for me and my clients. And so it is more expensive.
Right. And it's more complex, Judge. I know that you stepped up to the bench in 2006, so you don't know what it was like before BAP-CEPA. Right. But you've probably heard the stories from other jurists who have said, oh, it was a lot easier back in the day.
Yeah, it's not so much hearing the stories of the jurists, and it's not that it was so much easier then. There's a whole different approach now. One of the things that would be so beneficial for George and his clients would be if he was able to find a way, either with a trustee or on their own, to have a short sale. But to do that, they need the creditor's approval, and they're just not getting that approval to have a short sale. Short sale, selling the property for less than the debt, and the bank walking away with at least whatever the monetary value of their collateral is.
And why do your clients not want to do that when they can walk away with something as opposed to who knows what?
One overwhelming reason that I've found out that they're afraid of short sales, and I'd have to say it's psychology of the debtor, for want of a better term, and I'll tell you why. Because the short sale process is relatively easy to go through, despite deadlines, hardship deadlines that have to be adhered to. You really don't know what you're getting into with a lot of these short sales. You could end up with a borrower who has every incentive to literally trash the house, and frequently does so as kind of a last thumbing their nose at the bank, because the borrower knows that they're walking away with nothing from the short sale other than the peace of mind of not having to go through foreclosure. They know that a short sale, contrary to popular belief, is going to leave their credit just as damaged as a foreclosure would. They know that they're not going to have a house going forward. They know they're not going to come out of this closing with anything. And so they really have very little incentive other than signing a few papers to cooperate with the bank.
George, you've got to react. Oh, go ahead, Judge.
Don't they also have the real risk if they do that, if they trash the collateral, of losing their discharge?
Yeah.
And if they lose their discharge, I mean, that's the whole reason that somebody would want to go into bankruptcy, would be to get the discharge of the debt. The house is sold, but you still owe $20,000, $50,000, $100,000. In the bankruptcy, if they do the right thing and they don't trash the house, that's discharged. If they mess up the collateral, whether it be a car or the home or anything, then they run the risk of losing their discharge.
That is a risk. The judge is correct in a bankruptcy filing. And a related risk, which a lot of my clients either sweep under the carpet or don't actually specifically address, is the question of a deficiency. Typically, if they have a short sale, there's got to be some dealing with a deficiency that my clients may have. Frequently, they don't mention it to the borrower, and the borrower doesn't raise it either. So the borrower may find themselves stuck after the short sale with a deficiency that they thought they were walking away from with the sale of the house. Or if the borrower doesn't remain silent, the bank will say, okay, we're taking a short sale, but we fully expect you, Mr. Borrower, to be on the hook for a deficiency after the short sale. So that is another disincentive for these borrowers agreeing to short sales.
There's nothing that's necessarily going to be legally binding there. Let's get to some of your telephone calls. Richard from Allentown is up first tonight. Richard, good evening. What's on your mind?
Quick question, if you could. I'm bankrupt. I'm so far in debt. My income now is from Social Security disability. I fit into Category 2. Primary reason for the bankruptcy.
Richard, where are you now? Right now, you said I'm bankrupt. Do you mean have you filed for bankruptcy?
No, I have not.
Okay,
but I am without ability to pay my debt.
All right.
I have not filed. My income now, because I fit into that the second category of medical injury, is Social Security disability.
Okay. So what's your
40% of my debt is from student loans. I'm wondering under Chapter 7 whether any accommodations are made for that large chunk of my debt, which is coming from student loans.
George, great question, and I think not a great ending.
The Bankruptcy Code makes it very, very difficult, not impossible, but extraordinarily difficult to discharge student loans. However, in a situation like yours, what I suggest you do is call the lenders. The lenders and the Department of Education have income contingent repayment plans. They are not going to put you on the street because you have to repay a student loan. They'll take into account your situation. You might consider a bankruptcy for the non-student loan debt and then talk to the lenders for the student loan debt. But the Bankruptcy Code does not provide a very good remedy.
Sorry to tell you that, but there might possibly be some light at the end of the tunnel. Obviously, you need to sit down with an attorney and speak to him or her about that. Let's go to Alicia next. Hi, Alicia.
Hi. I'm calling to find out if somebody filed bankruptcy 10 years ago, can somebody come back and try to bring it and try to cause a problem for the person?
That's too general a question. You're going to need to be a little bit more specific than that.
If the debt existed in the first, did the debt exist and was it discharged by your first bankruptcy?
Right.
Then
Discharged.
Then the answer is no. It's discharged forever.
Oh, okay. Thank you. I just wanted to find out that question.
You're welcome. Thanks. And now I understand what she was driving at, too. Could somebody actually come back? One of her creditors, apparently, come back afterwards. One of the things that we discussed last time when your partner Dexter Case was here was the whole notion that there used to be a time where those who loaned money, especially when it came to homes, would not consider modifying that loan, would not renegotiate the mortgage. I hear that in this practice, especially since the Great Recession of 2008, going back to that hallmark again, that banks are more willing to do this. Is there some truth to that?
Absolutely, 100% truth to it on a number of fronts. And the Great Recession was really the catalyst behind it. Right now, I mean, there was always, unfortunately, the stereotype of the big bad bank, quote unquote. The big bad bank wants my car, wants my house, fill in the blank. But in reality, all the bank wants or the lender wants is what it put out in the first place, money. And all the borrower wants is to try and make good to get back to an even keel, where they once were. So with those two opposing viewpoints and with the background of the Great Recession, going forward, there has been a groundswell of openness between the banks, the lenders, and the borrowers since 2008. You see in the counties, for example, the mortgage foreclosure conciliation programs, of which my home county, Philadelphia, has been the inaugural model. It used to be when there was a mortgage foreclosure case filed, the borrower was just left to fend for themselves if they didn't have an attorney. Now, in Philadelphia, again using that as an example, if they own the real estate that's being foreclosed on, are automatically subject to the mortgage foreclosure conciliation program, where they have the opportunity to meet with housing counselors, lawyers, somewhere to form a loan modification to make it a little bit easier.
So in some ways, George, everyone wins?
Oh, yeah. The mortgage modification programs are much more prevalent than they were. We have a lot of clients. I have clients that are in Chapter 13 bankruptcies, which generally cure mortgage arrears over a 5-year period, that all of a sudden get their mortgage modified, and they can jump out of the bankruptcy because they no longer need that to modify the mortgage, or they'll file a Chapter 7 to get rid of credit card debt, get a loan modification agreement with their mortgage lender, and they have the best of both worlds. No unsecured debt, and their secured debt now is manageable. So Brian's right. His clients have really stepped up and are modifying a lot
And
of
again,
mortgages.
this is not simply, okay, we're going to give you a better interest rate, or we're going to take your 15-year mortgage, Mr. Smith, and not you, Mr. Smith, I'm sorry, it's a bad example. Mr. Jones, we're not going to take your 15-year mortgage and turn it into a 30. I mean, that's modifying a mortgage. I'm talking about the principle itself.
Right.
And that's happening.
It is. It's happening more than ever before.
Yeah,
but
we've seen some write-offs of principal.
Right.
Yeah.
That's interesting.
Yeah.
And it keeps being,
from my perspective,
Judge.
From my perspective, I'd love to sign the orders dismissing the case or approving the modification or granting the write-down, all that kind of thing. I love that kind of thing because that's what we're supposed to be doing. We're supposed to be trying to rehabilitate the debtors and allow them to get on with their lives.
Right.
That is the overwhelming goal, but I'd just offer one sort of caveat to the whole modification trend. If a loan goes into default through unemployment of the borrower, and the borrower remains unemployed when going for a loan modification, things aren't going to change all that much. It's something that the creditors have to be, as well as the borrowers, have to be cognizant of when they think about a modification, because modifications may go belly up just as the original loans went belly up for the same reason, namely unemployment.
Right, but the question is, if there's a modification, the interest rate may go down, the amount that you're behind can be thrown to the end of the loan. All of a sudden, a mortgage loan that becomes a mortgage loan that was very unaffordable may become very affordable, even if the employment doesn't exist, then zero is zero, and nothing's going to happen. But if you're underemployed, if there's been a job loss or a loss of income, and now you're back working, the loan modifications help enormously. And one of the best developments that I've seen is that now the lenders apparently don't care if you are in a bankruptcy. At least many of the lenders I've seen don't care if you're in a bankruptcy. It used to be that if you filed a bankruptcy, you wouldn't be considered for a loan modification. Now they don't seem to be concerned about that.
There's a second or a third or fourth category, whatever it is, of those that might qualify for it, and that is in today's society, there are so many dual income couples that one loss of a job knocks you out of being able to pay $700 a month, but the other job would still allow you to pay $500 a month. And so I've seen the modifications where one of the two household members loses their job, but the other doesn't, and they're able to recover them.
And Judge, do you find that most debtors' attorneys are quite cognizant of the fact that this is quite negotiable, where maybe 5, 6, 7 years ago it would not be?
Whether I find that yes.
Okay.
More of the attorneys.
I got smiles of the other attorneys here on the set. The attorneys here on the set tonight.
There are still those attorneys. The biggest issue, one of the big issues with BAPSIPA was that it really required constant attention to dealing with the changes in the law. And a lot of those who dabbled in bankruptcy, who filed an occasional case here or there, stopped practicing bankruptcy. And there are still those that do that don't really know everything that might be available.
Folks, we are unfortunately out of time, but that doesn't mean you can't keep calling. There's a number on the screen. It'll be popping up there in a moment. We're going to continue taking your telephone calls after the half hour, and I think we're still streaming on WFMZ.com. So if you want to go over there and listen to some of these questions, or stay on the phones, or give us a call there at that number, we'll do our best. I want to thank my guests this very quick, riveting half hour. George Lutz with Case DiGianbardino and Lutz, 3 or 4 locations throughout eastern Pennsylvania, and George is in the Allentown office. The Honorable Richard Failing joining us tonight for the very first time with the U.S. Bankruptcy Court in the Eastern District of Pennsylvania, and Brian Smith with Lamb Rubenstone representing the creditors, I should say, the lending institutions and the banks. And for all of us here at the American Law Journal, until next week, case closed.
Tonight's American Law Journal has been made possible in part by Case DiGianbardino and Lutz, since 1984, providing their clients in southeastern Pennsylvania with professional and competent legal counsel in matters involving personal and corporate bankruptcy, debtor and creditor rights, zoning and real estate development, with 3 offices in Reading, Allentown, and Lancaster.
Land Rubenstone, a law firm providing litigation and transactional support to business and leading institutions, as well as legal advice to individuals for over 25 years. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.